My name is Samira Nazem. I work at the National Center for State Courts, and I'm joined today by Kathy Laporte from the 61st District Court in Grand Rapids, Michigan, and by Alexa LaBeouf from Cassette Consulting, based in Chattanooga, Tennessee, and she works with the Hamilton County Courts there. I'm going to give you a quick roadmap of what we're going to talk about for the next hour and change. I'm going to start off with just kind of a quick overview. We're talking today about eviction diversion, and I would like to help define what we mean when we use those words, at least for the next hour. I'm then going to turn it over to Kathy and Alexa to tell you a little bit more about their programs that they have implemented in their respective jurisdictions. And then at the end, we're going to have a discussion to talk a little bit more about kind of what we have all learned doing this work, how technology can improve it, and we would love to hear from you about similar work happening in your jurisdictions and courts, and to answer your questions at that time too. So I think we'll have someone running around with a mic, and we really do want to hear from you. So please be saving your questions till the end. All right, so to start off, just a little bit of background on what we're talking about, at least for these purposes, when we refer to eviction diversion programs. And I'll just kind of go back in time, do a little bit of a how did we get here. So eviction diversion programs existed before COVID. They certainly weren't just invented and created out of nothing in the last few years, but they certainly have really expanded and taken off during the pandemic. Over kind of those few years of the pandemic, we saw dozens and dozens of new programs that were launched. Many of them were based within a court system. Many of them were based outside of a court system. Most of them are really centered around trying to find ways to get that federal emergency rental assistance funding out as quickly as possible to help people who are in crisis and to try to stem off this forecast tsunami of evictions that people were anticipating. At the same time, there's also a lot of federal funding that became available for increased legal aid, mediation, housing counseling services in many jurisdictions as well that really kind of supplemented those efforts to push out the rental assistance dollars. One of the really exciting things that we saw was state courts really taking a lot of ownership over this work and working very closely in partnership with government partners, community organizations, legal aid, nonprofits, to try to establish new collaborations and new programs and to do a better job of helping to connect community members with these stabilizing resources that existed in their community. And of course, technology played a huge role in these programs, being able to operate at scale, especially during those kind of early months, years of the pandemic. So that kind of led us to this what comes next question, where a lot of courts created these programs really quickly, and then we're kind of at this crux trying to decide, is this a temporary pandemic response project, or is this something that can become sustainable and permanent and woven into the fabric of our court system? So at the National Center for State Courts, we saw this opportunity to really work closely with courts to think about how they could take some of those emergency response programs and pivot and make them permanent. And we launched our Eviction Diversion Initiative, which is a 4-year grant program that offers funding to state and local court systems to hire staff to build out their eviction diversion programming and to really try to build on and institutionalize some of those pandemic era programs and process improvements to make permanent change in how these eviction courts work. I'm going to give a quick plug for this program, and I will tell you why very shortly. But as participants in the EDI program, courts get not just money, although everyone likes getting money, but they also have access to technical assistance, to peer learning opportunities, and to a lot of other supports from NCSC staff and other program partners. And you'll hear a little bit more about what that looks like on the ground from my colleagues in just a moment. But I mention this because we will be opening an application next week for a second round of grant funding to bring more courts into this. And so if any of you here are representatives from court systems or work with your court systems back home, please know that. Check out our website and think about whether your courts may want to kind of participate in this work and submit an application. So in our first round of funding, we were able to give out grants to 12 courts on this map here. We've done, I think, a pretty good job of trying to cover the country, although we have a few kind of gaps that we'd love to fill in on our next round of funding. And we have just 2 of our representatives here, but I'll try to touch a little bit on some of the work that's happening in some of these other courts as well. So that's kind of the high-level overview of kind of our program. And now I just want to take a few minutes to talk about what we're actually doing with this grant funding. What is an eviction diversion program? I know that it is used in a lot of different ways in a lot of different jurisdictions. For our session today, we're really focusing on court-based eviction diversion programs. And for that, we're talking about programs that are using the court process, such as it is, to connect litigants with time, information, and resources to resolve a legal dispute in the least harmful way. I'll elaborate on that quickly and then let you hear directly from people who are doing this work on the ground. So the resources piece is I'm going to start with that because I think that's really the key to an eviction diversion program is you need something to divert landlords and tenants to. So all of these eviction diversion programs have to build out some kind of referral network and to bring in all of these services and supports to help landlords and tenants find a way to resolve their issue. Even the most highly motivated landlords and tenants will often need help, whether it's cash or a mediator or someone else to help them find a way to move past this immediate problem. So all of our courts focus on building referral networks that include opportunities both to resolve the immediate legal crisis, that issue that has brought people into the court system, but also to think about ways to resolve any underlying issues that may bring people back into the court system afterwards. So we want to not just be a Band-Aid, but also get to those underlying root causes. In terms of resolving the immediate crisis, all of the courts that we work with have really found ways to integrate legal aid and pro bono services into the court process so that landlords and tenants are able to understand where there may be meritorious defenses or procedural defects in a case, and also to get help with settlement opportunities. Mediation is another really common partner that we see in many of our programs to help litigants find that neutral ground and work together towards a resolution. And then, of course, financial assistance. The rental assistance program that I mentioned earlier, and other jurisdictions may have cash assistance or utility assistance programs as well. So all of those things that can help to stabilize tenants' financial situation. In terms of thinking about some of those underlying root issues or those interconnected issues, since we know so many people who have one legal issue have others underneath the surface, we also have courts trying to bring in housing counseling and financial counseling services so that someone leaves court but has an opportunity to think about putting themselves on a more stable path moving forward. And then we've seen courts bringing in social workers and supportive services to help facilitate that access to education or employment or food security or whatever other needs someone may have. We have one court that has a partnership with a local laundromat, so people can go and get their clothes washed for free if they're experiencing housing instability. So really thinking not just about the legal needs, but what are those human needs that people have that they need help with on a day-to-day basis as well. Because we are coming at this from the court perspective, I always like to talk a little bit about how courts can be good partners. I know we're probably a legal aid heavy audience here, but one of the things that we find is that courts historically aren't used to playing well with others, and there's a bit of a learning curve there. So we try to help courts understand what it takes to be a good partner with legal aid org or another social service provider. And that means taking the time to understand what they do and how they do it, learning about an intake process, learning about the timing, eligibility criteria, and all of those things. So when someone's referred to legal aid, it's not just a black box. They have an understanding of what comes next and what the legal aid organization may be able to do. We, of course, encourage courts to communicate regularly with all of their partners so they're not giving outdated information, so that there's a feedback loop and they can hear directly when things aren't working well and when there's opportunities to streamline and improve some of these referral procedures. And then, of course, we want courts to prepare litigants for what's going to happen next when they go to that service provider. Where do they go? What do they need to bring? What should they expect? Can we put that in writing so that they have something they can refer back to afterwards? We have one of our courts in Lansing, Michigan, where they have a partner who's a financial counseling organization that's given the court staff access to their calendar so they can go in and schedule those financial counseling appointments directly for the litigant. So they're removing that barrier. The litigant leaves and they know exactly what time and where to go for their appointment. They don't have to call a number and schedule it themselves. So anything the court can do to make those referrals a little bit more seamless, a little more streamlined, can be really helpful since we all know that once someone has to visit another website, call another phone number, go to another office, you're increasing the odds they're never going to make it to that service provider. And then, of course, we want our courts to be good at sharing their space, sharing their data, sharing information, and doing all of those things that can make it easier for legal aid and other service providers to work with people. So a few examples from eviction diversion programs around the country. I've got here kind of a low-tech, if you will, and a high-tech version of this. So on the left, we have Lawrence Township, Indiana. Their court is primarily in person, and their services are delivered primarily in person. So when you walk into that courthouse, first you see security, because that's always first, but second, you see smiling people with a big sign that says, hey, free legal assistance, free rental assistance, and those services are available on site during every eviction call for tenants and landlords to access. On the right, there's kind of a virtual equivalent of that in Cook County, Illinois, which is very high volume in a large geographic area. And so the program operates remotely and on Zoom through the magic of breakout rooms. Case managers who work with the judges can move people in and out of breakout rooms to meet with different service providers. And there's a session just about that program tomorrow. So if you're interested in how that works, kind of in a high volume, fully remote setting, you can learn much more about that tomorrow at 10:30. Now, on the left here, even though those services are all in person, there's still ways that technology kind of enhances that in-person service delivery. So these are also pictures of the same court, and you can see they've got those Zoom robot things that walk around where people can kind of check in, and once they've checked in, they get text message notifications telling them where to go. They can get sent to this room on the left here where they can go through an intake process. They can get sent to the room on the right where they can meet with attorneys, and these text message nudges are kind of directing them throughout the courthouse so that they can move from one service to another. So even though something is in person, doesn't mean that there aren't roles where technology can make it all a little more efficient for the user and for the service provider and for the court staff who are kind of overseeing this project. So the second piece of this, other than the referrals, is thinking about timing. And that's been a challenge in a lot of areas where evictions move notoriously quickly, and there are often these very rigid statutory markers that must be met. But the diversion programs need time to work. If a court is going to facilitate these referrals to legal aid, mediation, whatever it is, it's going to take some time to access that service or that resource. And the court and the service providers need to work together to make sure that there's enough time for all of these things to work well. So when we think about all these eviction diversion programs, every court that we work with has to make a decision about where are people going to access this service. At what stage of the eviction process is this diversion program going to primarily operate? So this is kind of a pretty simplified map of how most eviction cases flow in jurisdictions, not everywhere, but in most places it's some version of this. There's a notice that gets served. After the notice period expires, there's a case that's filed. The summons and complaint are served. The parties go to court. And then there's some kind of judgment, trial, whatever it may be. So if we have a diversion program, what we want to do is build in these off-ramps, right? So at some point before that final trial, the parties get a chance to go into the diversion program to work with this network of service providers and to resolve their issue without going through this full litigation process. A program can take place pre-filing, so you're trying to get people to not even use the court system, but to get diverted before something is filed in court. It can be post-filing, so you've got that period of time right between where a case is filed and when the parties actually go to court. In some places, that period of time is really short, but in some it can be weeks or months. And so you've got that period of time where you may have a post-filing diversion program. And you'll hear a little bit more about what that looks like from Kathy. That's how the program in Grand Rapids kind of operates. And then in-court programs where you're catching people at their first court date and using that moment in time to get them connected with the diversion program. There are pros and cons to any of these, and probably the gold standard program would have multiple off-ramps at all of these different junctures to connect people with diversion. I'll just kind of quickly give some examples of what these look like in practice. For pre-filing programs, they can be mandatory or voluntary. We've seen both. Washington State is an example of a mandatory program where all landlords are required to give tenants information about mediation and 14 days to opt into mediation before they can file a case. If the tenant doesn't take that step within that 14-day window, then the landlord can move forward with filing. Alaska, which is one of our EDI courts, is doing a statewide voluntary pre-filing program where before a case is filed, landlords are encouraged but not required to use mediation services, and both landlords and tenants have access to kind of legal advice that's delivered remotely by phone. These pre-filing programs can be really well suited to kind of remote programs because they're not tied to a specific court event or a specific date. With the post-filing cases, because the case is already moving and that statutory clock is already ticking, it's important to think about how that case can either be paused or slowed down to allow the diversion programs to work. We have some courts in our EDI program that are pausing the case. Indiana is one where if the parties agree to go into diversion, the case is stopped for 90 days. In Michigan, it's a little bit less rigid. If a rental assistance application is pending that could resolve the case, then the case can be temporarily paused also. And then in Cook County, which is a program I mentioned earlier, it's less of a pause and more of a speed bump, if you will, where the cases go before the court for a case management date, and then there's a minimum 14-day continuance to allow everyone to kind of access those diversion program resources, and then it comes back to court and moves forward. All right, and then the last piece that I will touch on before I turn it over is information. So with all of these things, you can build the best eviction diversion program in the world with 12 different off-ramps and 100 different service providers, and it's still a bad program if no one uses it, right? And we know that eviction cases suffer across the country from chronically high default rates. And so one other thing that is crucial for courts to think about when designing a program is how will we get people to come to court and use this program and access these services? So kind of the two things that we talk about a lot in our eviction diversion work are looking at those existing nodes of communication from the court and thinking about how they can be improved, and then also looking for ways to supplement those as well. So we know courts are already reaching out to people. The summons and complaint are getting served. There may be postcard notices that are sent out. Whatever those existing methods of communication are, there are almost certainly opportunities to make them better, right? Are they plain language? Are they designed in a way so that they really prioritize the most important information? Could someone, a reasonable person, look at this and understand what they need to do and when they need to do it and why they should do it? In most courts, the answer is no. And so there are a lot of opportunities to look at those existing touch points and to improve them. All of those existing touch points, too, are opportunities to send out supplemental information about a diversion program and its benefits and resources. And then, of course, beyond that, there are other things that can happen. Text messaging reminders, email reminders, many of our EDI courts are using those. And then kind of that grassroots community outreach partners, finding your kind of trusted intermediaries on the ground to kind of push out that message into communities that may not always have reason to trust messages that come directly from the court. And just thinking about a lot of other ways to kind of reach people through different methods to make sure that everyone understands that there are resources at court. Maybe you've come to eviction court in the past, but this is a different court with a different program and different resources. All right, and then to kind of wrap up, just a few kind of communications examples. In Grand Rapids, the court mails out proactively information about eviction diversion to every tenant as soon as the case is filed. They're not waiting for that summons and complaint to go out because that's wasting valuable time when tenants could be accessing resources. So the court is proactively sending out a mailer as soon as they have that physical mailing address. In New Jersey, the landlords are required to provide the tenant's phone number and email address. So the court has that information, and that can open up other ways to facilitate communication with the tenant beyond kind of that summons and complaint, relying on the physical mailing address. So there are kind of a lot of ways in which communications can move beyond what courts have typically done. And then just a few examples here of flyers and door knockers and other things that are being used to really reach people in ways other than that traditional kind of summons and complaint with that very formal kind of legal jargon and legal look to it. All right, so with that, I'm going to kind of stop and I'm going to turn it over to Kathy, who's going to come up and talk about her program in Grand Rapids.
All right, thank you very much, Samira. All right, so at the 61st District Court, excuse me, we take a holistic approach to assist landlords and tenants with not only rental assistance, which we find is far less available after the post-COVID era ERA or emergency rental assistance, but we work with them to gain the tools for education, employment efforts, financial management, needed to sustain affordable housing and achieve financial stability. As Samira mentioned, we are addressing that root cause at the earliest intervention point possible. We work with them throughout the whole process of eviction in our courthouse, up into the second hearing, which includes the trial at times. So we run the gambit, but we do hope to reach people at that earliest intervention point. Our program was kind of born from a pre-COVID eviction prevention program, which was piloted in partnership with the City of Grand Rapids, our city government, our Department of Health and Human Services, and the Housing Assessment and Resource Agency, part of our COC for our region, which is the Salvation Army. This program piloted from 2018 to 2020. And that EDI program, my EDI program, serves to kind of fill the gap of direct case support that doesn't exist with that eviction prevention program. Something we learned in that pilot was how important it is to intervene with that kind of social work element of trauma intervening and identifying the root cause to build skills so that they can prevent ending up in this situation in the future. We found a lot of times people kind of just stumble into eviction. So some of our program elements include robust partnerships with social and legal service agencies, including alternative dispute resolutions, legal assistance, non-legal housing counseling, financial counseling, of course, rental assistance, employment support, but also victim and incarceration support. Our court process follows summary proceedings for virtual and in-person. Currently, we still have first hearings, which are part of a COVID era procedural changes that are currently up for review. That includes the first hearing, which includes the advice of rights. So during that first court date, the judge reviews the standard advice of rights with each defendant and then also gives the defendants an option for entering a breakout room in the Zoom session with our social service representatives, including the Salvation Army, our Department of Health and Human Services, to look at state emergency relief and other state and county benefits. And of course, Legal Aid of West Michigan is present in there. They do initial intake during those sessions. There's a second court date where participant cases are heard, and if it doesn't yield a decision, it goes to trial. And on a case-by-case basis, currently the judges may require a denial letter from the ERA providers if there is an application, a viable application out. They will require that before they file a writ on the case. So as I said, many of the COVID-era procedural changes are currently up for review. This includes the first hearing advice of rights and the stay for rental assistance applications. Our program is working in conjunction to keep those provisions while they're up for review at the state Supreme Court. It's through extensive marketing and outreach efforts that we attempt to reach during the pre-filing stage. It's the most effective stage for intervening. During the pre-filing stage, intervention is heavily focused on education, awareness, and preparation for what's ahead, and to potentially derail that court route. We work with our local rental property owners association to perform lunch and learns sessions that are geared towards shifting landlord mindset to a proactive approach to non-payment issues. We see a huge issue with the wait and see, trying to give a lot of time, and I'm sure you all enjoy those conversations. But we work really hard to kind of curb that mindset to the first notice. If your tenant's letting you know, we want to work with them. It's through our partnership with the Dispute Resolution Center serving West Michigan that we provide warm referrals for mediation. They usually respond within the first 24 hours of the referral. They offer a non-adversarial option to give landlords and their tenants a chance to resolve eviction case without the trauma of court involvement at low to no cost. Our local legal aid has also assured us that earlier intervention works best for their referrals, so we're working closely with them to determine what are viable cases to send in that pre-filing stage. So we send cases that involve housing vouchers or for subsidized housing, and if there's disputes in addition to non-payment. With each referral that we make, we are preparing the client for what to expect with their interaction at each agency, trying to stay very trauma-informed with this process. Some of our post-filing interventions, in addition to those pre-filing, we'll work the pre-filing interventions at any point as we can, but as Samira mentioned, timing is a greater factor the further along in the process they get. So we do mail out the flyer as a flyer ahead of the complaint and summons, and with the complaint and summons. We offer emergency rental assistance access through our in-court sessions and also by referral. We provide warm referrals to our legal aid and legal self-help centers, and then we also work with crisis planning for in the event that the writ comes, what are you going to do? Trying to get the forward-thinking process on that. And this is just an example. As you can see, this is the exact flyer that we mail out. It has like an act, learn, and get help session. So we're trying to educate them, our clients, the litigants, on the process to try to prepare them for the process that's ahead, but in a way that encourages them to reach out right when they get that mailer. We distribute this through our marketing partners. We utilize zip codes with the highest filing concentration for targeted outreach to area businesses and especially nonprofit agencies that serve a lot of the folks that we would be seeing as tenants. And we also provide a QR code for easy access to our intake survey so that they can self-complete that intake survey. It's populated to us on our end, and we can reach out to them very quickly. And that is all I have. Oh, folks. Yeah. Oh, my bad. I forgot I switched slides. Psych. The user experience and anticipated changes. So our court presence has existed since the eviction prevention program in 2018. We had partnerships with the Salvation Army, Legal Aid, and Department of Health and Human Services, and they still remain as part of that permanent program. And it's very helpful to have them on site or on Zoom, where folks who come in person can be assisted to access Zoom on site. We do have Zoom hearings where we're trying to create a PowerPoint to deliver the advice of rights more uniformly. Right now it's kind of just the cattle call and judges screaming it out whenever they can. And creating a mailer for how to attend via Zoom, because we're finding that that's a strong amount of the calls that we get for our diversion program is actually how to access that Zoom hearing and how to navigate that. So we're hoping to produce that and have that go out with our court mailer with the complaint summons. All right, and we do advocate for changes. So in addition to the client work that we do, we work towards maintaining the COVID era provisions, canceling the default judgment for failing to appear unless they're served personally, increasing tenant representation, sealing eviction records at the point of filing, and a path to expungement for those who are unable to avoid the writ of eviction. And that is the work that we do. Well, sorry about that.
Hi, everybody. I know I'm the last face that you'll see before happy hour, so I appreciate your patience. The Eviction Diversion Initiative in Hamilton County, Tennessee is in its very early stages. So a lot of this is going to be giving context for folks who might be in the initial steps of trying to think through a diversion program. A little bit of information about Hamilton County, Tennessee. It's in southern Appalachia. There are 4 significant big-ish counties in Tennessee. That's Davidson, Shelby, Knox, and Hamilton. Our city, our largest city in Hamilton County, Tennessee, is about 180,000 people, and that's Chattanooga. But the court system serves about 380,000 residents. We're 2 hours north of Atlanta, 2 hours east of Nashville, 1 hour from Dollywood. All right, so the way that our system works, we have 5 general sessions judges. They handle civil cases that are for under 25,000. Prior to this new year, our detainer docket would be handled through like an interchange of those 5 judges. So every Thursday, we would see all of our eviction docket happen. It would be the pro se landlords, the represented landlords, and our housing authority. Prior to COVID, they split it up throughout the day. Now it just kind of all happens in one shmush, right? That docket is read for everybody who's facing eviction on that given Thursday. And it doesn't matter if you're gonna be heard at 1 p.m., if your name is called at 9, you thought you could come in at 12, it's not gonna work. You need to be there when that docket's read. And starting this year, we've had a significant change under a new attorney general where we're seeing a shift to vertical prosecution, which is affecting our the way that our judges are overseeing civil cases. So starting At the first of this year, we'll be just having 2 judges who will be overseeing the detainer docket for an extended period of 3 months. So that's kind of a background about the structure and what we're seeing in Hamilton County. A background about this program and how we ended up coming into an eviction diversion program or starting to think about it was when COVID hit, when all of us were scrambling, we were trying to think of how we could respond to it effectively. One of the ways that Hamilton County responded was by forming a court-adjacent program called the Eviction Prevention Initiative. And the goals of that program were to expand access to legal representation. But what made this program unique was that we also had social workers tied, because we understood that having representation mattered, but we were seeing folks within a continuum of housing instability, right? Like perhaps at this moment in time, we could be able to avoid an eviction, but someone needed to work with them over a long period of time so we didn't see you back in court. And what that Eviction Prevention Initiative did was it taught us a couple things about what it really meant to serve folks, the role of legal intervention. But one of the biggest successes was that we started having landlords come to us proactively. The way that I described it is like nobody loves eviction court. Like nobody wakes up in the morning, judge, plaintiff, landlord, tenant, and goes like, this is like my favorite day of the week, right? When we started having people in eviction court willing to triage resources and work with folks and find alternative solutions, landlords took notice, as did plaintiffs' attorneys. And so we had people coming to us proactively and saying like, listen, I have a tenant, can you help? And right around that time, the National Center for State Courts grant was released. And so we had this like window of opportunity to take hold of this dynamic shift that was happening in our community and our courts, because we still have a pretty significant number of pro se landlords and small and medium-sized landlords that we can really build relationships with, to take the model of our court-adjacent program and our successes from that and move it into the court itself. And so I'm going to go over some of the strengths of what we're looking at around our program as we're thinking through what this could mean, as well as some of, challenges reworded as areas of growth. All right. So one of the assets in Hamilton County's courts is that we really came to this as let's find a solution that's mutually beneficial to both parties. It won't always be the case. Sometimes litigation is where it's going to go. But in thinking through what we were going to do in an in-house court program was we needed to find solutions that made the whole system more fair and more effective for both parties. And some of y'all have maybe heard about Hamilton County, given some of our judicial leadership. Judge Alexander McVeigh led the medical debt ODR program with a local hospital. We have a couple problem-solving courts that have also gotten some attention, a mental health court, a drug recovery court. So Hamilton County has a history of thinking creatively and strategically about problem-solving initiatives and dispute resolutions. This was just our move into the housing court space. And so mutually beneficial, thinking through it for all parties, that's asset number 1 from Hamilton County, Tennessee. The other is that it's collaborative. What's been really exciting about this is here we are in a mid-sized southern city, and this program was a result of our county government working with our city government, working with our judges, and working with our courts. And this was a pretty significant accomplishment for us to be able to bring everyone to the table and find a solution for something that was creative and forward-thinking that involved multiple municipal governments. So the National Center for State Courts, one of the greatest things we have now is a full-time housing stability facilitator. And she's reporting to the court and the judges and the county, but she's also from the city of Chattanooga's mayor's office. So you're seeing these high-level commitments from leaders in our community who are working together to try to find solutions. And even if and when perhaps they don't have a long history, like a city government, of getting engaged in a county court system. I guess I got ahead of myself. So asset number 3, the history of problem-solving court. Again, mental health court, drug recovery court, the medical debt online dispute resolution program. And now with the addition of Yashika Ward, we have a housing stability facilitator. And what that's gonna allow us to do is figure out how we can triage between all these problem-solving solutions to try to better serve families. asset number 4, we really just stepped through a policy window of opportunity. Anybody who's taken like a public policy 101 class, your professor's like, it's both a mix of everything, all the hard work you do and that little window being open in that moment of time that you step through to really see significant system change. And that's really what happened. I think a lot of our communities, the metaphor that's constantly being used is the pandemic was like a magnifying glass on the pre-existing challenges. And as difficult as those were, what it did was have a lot of our communities confront some of the pre-existing inequities and challenges that existed prior to the pandemic. And in that space, a window opened for a lot of us to try to make some system changes and try to get some things through our systems that perhaps we wouldn't have been able to in 2019. And what I mean by that is there was a very huge, significant focus on housing, I'm sure in your communities, but in Chattanooga, we were seeing a lot of folks who no longer had to work in their IT department, realizing they could cash out on their property and move to a small town in Tennessee and have a couple acres. That's wonderful, but it's changing the housing landscape. And that reality meant that people were paying a lot more attention to how housing was affecting the local community. We got a new city mayor as well as a new county mayor, and so we were just really ready and able in this window of opportunity of attention and focus to get some things done. Areas for growth, we have a lot to do around the age of our system, around making sure that our systems are communicating with each other. Hamilton County, I call it, it's like a lot of mayors in Hamilton County, all right? We have a lot of municipal governments, a lot of commissioners, a lot of city councils, and all these systems aren't necessarily communicating with one another. So there's a lot of improvement both internal to the courts as well as the way the court system communicates out. How do we think about data? Do we see it as just a way to collect information about something that happened, or are we trying to actively ask questions of it in order to solve real-world problems? This is a huge area of growth for us. How will we use data? How will we analyze it? As well as coordination between public and private systems, and I'm sure all of y'all are facing that as well. Areas for growth, one thing that has come up for us, because we're new, we're nascent, we're just starting to think about these things, is what's actually sustainable. I know both Samir and Kathy mentioned the role of the fact that rent relief is lessening. It's going down. That was a primary driver and tool that we were using in the court adjacent program and that our housing stability facilitator is currently using right now. If we can get bills paid, then we can divert. We'll keep landlords happy, we'll build those relationships. Well, our Tennessee Housing Development Agency on January 6th stopped applications. So this intensive push that we were doing to get people through the system and get months of debt remediated is no longer an option for us. And so our current focus right now is around the communication and engagement strategies. So we'll be looking at text message systems, flyers, all the cool things that you heard that were happening with Kathy's program. We're gonna start integrating those as well as court signage and iPads. But a more longer term strategy that we started to undertake is what would a mediation program look like in Hamilton County, Tennessee? And then lastly, policy solutions. I always try to super personalize it in the sense that if I'm a landlord, I've owned my property for 20 years, it's one of 3 assets I have, the HVAC's broken, I'm looking at a $20,000 bill, and I'm having issues, and I'm in and out of court, and an investor comes to me and says, let me take that off your hands, I might do it, right? That's my retirement, it could be a huge medical debt bill I'm paying, a student debt payment for a child of mine. And so maintaining those existing affordable units is also a priority. And so we're trying to figure out as we do this work further down the pipeline, like what are the incentives we can give landlords to keep them in the market? Like I know Todd, I see Todd at Food City, he owns 6 properties, all of them take vouchers. Like I don't wanna lose Todd. And that is a focus of a lot of our work is how can we take what we're learning here and extend it out to larger policy levers. And healthy dynamics, as always, when we're building out these programs along a continuum of care, how is everybody engaging with one another, whether they be court adjacent, whether they be in court, whether they be at that mayor's office or this mayor's office, in order to best serve households. We have a civil clerk and a criminal court clerk at the Hamilton County General Sessions Court, and we're also thinking about those dynamics and those relationships. And lastly, how do we do this in a way that is mutually beneficial for tenants and landlords? So I think we're good. I'm a fast talker. All right.
Okay, so we wanted to take our last, this is on. I'll just kind of We wanted to use our last 30 minutes or so to have more of a conversation. I made a list of questions to ask them ahead of time, but we'd much rather answer your questions or hear about your programs or reactions to any of this. So if anyone has questions or wants to share anything that's happening in their courts, we'd love to hear from you. Could we get someone to run around with a mic? Awesome, thank you.
You spoke earlier about slowing down the process or creating some sort of speed bump to allow for diversion. As I think most people in this room know, some of those timelines are really, really short. Do you have any suggestions for ways to increase those, or how to get people who have a lot of power and who have a lot of influence, who are very invested in short turnaround times, to get on board with diversion?
I mean, it's a great question. I don't know if either, let me let Kathy and Alexa kind of weigh in a little bit on kind of maybe judicial champions, right? Because this requires a lot of buy-in from the court and from kind of other decision makers. And could you both kind of share a little bit about who are your champions in your respective courts, and to the extent there were changes that need to happen, kind of how that happened?
Yeah, so up in Grand Rapids, we've had to utilize a lot of the kind of mentality shifting and understanding that this is a group problem, with a group solution. We've relied a lot on city government. Our community development office has been a major role playing in this for the county as well, looking at creating a sample of the 61st District Court in Grand Rapids for the other courts within the county, because we don't have that coordination between the courts in our county. So we've also relied a lot on our judges. We have a couple, our chief judge and another, that have been champions since the very beginning, and the remaining of them have kind of come in along shortly thereafter that pilot ended. So the pilot did a lot of help as well to kind of create the data that we needed to kind of go along with the stories that we could see with our eyes and experience. So that really helped to coordinate and further that.
We too relied heavily on visionary judicial leadership. Hamilton County is very blessed to have incredible general sessions judges. And again, Judge Alex McVeigh, who has just always been very visionary in how work gets done and how it happens. And the medical debt online dispute resolution program has been successful. Just recently released their one-year report, looking to see if other hospitals would be willing to work on medical debt resolution in that way, and was very supportive of the application of this grant, the implementation of it. We have an incredible chief court administrator who helps with just the nitty-gritty logistic-y stuff that happens when you're trying to get things done, and systems that have been around doing their thing for a while. And of course, City of Chattanooga Mayor Tim Kelly was fundamental in working with the judges to apply for this grant. Support, I guess, would be like the equivalent of our pilot, our court adjacent program, to like proof of concept, like this matters. But I think a key element of this was finding a way that it is a value added to landlords and property managers, and not keeping to an us versus them framework, and thinking through the fact that as housing providers, they're a key part of the solution as well. And that has been, I think, some of the key elements of buy-in.
Yeah, I think what Alexa just said there about bringing in the housing providers and landlords into this conversation is key. If you're trying to change timelines, whether that's asking for a rule change or a order from your Supreme Court or whatever it may be, it's almost certainly going to be an easier process if you can get some buy-in from housing providers and prove that this is a program, especially if it's a court-based program, that is benefiting everyone, that it is not simply a way to get tenants more time, it is a way to benefit kind of this community, all of the stakeholders, and the court. I will also say that we're collecting a lot of data from all of these courts, maybe more data than they wish they were having to collect. And it is our great hope that that will help demonstrate some of the benefits for this too. To the extent you need to make cases locally, that we can give you examples of what's happened and that the sky hasn't fallen. Just because people have 14 days now instead of 7, it actually turns out that it's okay.
That was my first question. It seems like you've had these magical cocktails of champions in both your jurisdictions, and particularly getting your landlord buy-in it's amazing. From our work, I think that's one of the hardest parts. I saw financial counseling on, I think, both sample jurisdictions, and one of the assumptions that we work with a lot, assumption busting that we do a lot, is that low-income community members are getting evicted because they didn't manage their money. And I'm guessing what actually is happening in that financial counseling is debt management and helping tenants with, that they're being evicted because they're drowning in debt. And so I'm curious to know how much of this eviction diversion has turned into a learning experience about the intersection of eviction and debt collection.
Oh, I can speak to that. Something that we noticed during the pilot program was just how much of it was just money mismanagement. It's the poverty mentality is very steeped in that as well. So we've definitely taken a very focused approach to working with financial counseling, but also, budget management or budget identifying, and working on a gradually disengaging case management model, because those are habits that have to be built up over time, that you can't just hand somebody who's experiencing trauma information about their finances. They're not gonna care. They cannot cognate that at that point when eviction is looming. So what we do is that we're building in our initial intake calls, we're having those conversations about those supportive conversations, but we're also working in the concepts of something, for forward notice is to work on budgeting and understanding that the less you have, the more important it is to manage. And so we kind of feed those ideas into our early conversations and build up into sharing specific financial counseling resources to them, because they need to kind of get through the initial hurdle. If we know they've secured ERA or emergency rental assistance, we're going to work to support them over to those resources a little more warmly and readily, because we know at that point they can start to take that on from a trauma perspective.
I don't want to sound like I'm saying that I buy into the assumption that people in the low-income community don't know how to manage funds. I think the community members we work with are exceptional at doing a lot with very few resources. It's that one thing that tips them over, and they don't, that they're struggling with debt coming from so many directions.
Yeah, this is actually perfectly well timed for Hamilton County. We just initiated a new research study with the Pew Charitable Trust locally in Hamilton County to ask very specific questions about the intersections of different debts people hold with housing courts. I think the last statistic that I saw about payday lending in Tennessee was that you can pay up to 450% interest. We do have some alternatives in terms of accessing refi opportunities through a nonprofit called BetterFi, but this is such a huge question, such a huge undertaking, the way that people engage with debt, what type of debt, the interest rates, access to banking institutions. But it's something that definitely our clients are dealing with, and we're hoping to better understand in Hamilton County.
Oh, you've got a few in the back.
How does your court deal with the uncooperative landlord and your month-to-month tenants? They simply do not want to contract with this tenant anymore, and they may take the rental assistance and then serve them with a 30-day notice terminating the tenancy. And my second question is, how do you deal with conditions issues? Because often we find the rental assistance is there, but the tenants are complaining of a lot of conditions issues, and we'll say, let the agency pay the rent, and then you can put your rent in escrow and go that route, which, it kind of pushes the can down the road. So it's kind of a double question, because we found that the landlords, we have a law that the landlords do not have to accept late rent. So if they no longer want to contract with this tenant and this person's on a month-to-month lease, they have every legal right to take the rent money and then serve them with a 30-day notice.
Yeah, that's a tough one. If I can, what we have found in our jurisdiction, like we have those conversations with the landlords and the tenant all the time about the additional conditions. When that happens, I'm looking immediately towards legal aid support for those disputes to see if there's merit to those and support. We also work with like housing navigation too in those and talking and addressing it. So it's really just a lot of conversation and dressing down the issue, boiling it down to the root cause, because when somebody is overwhelmed, in a state of overwhelm emotionally, they are, it's that kind of catastrophization. They're finding all the things, grasping at all the things that they can that point to this being a bigger problem. So we address those by kind of dressing down the issue with careful conversation, trauma-informed approach conversation, really. And as far as dealing with the landlords, I mean, you are going to meet a mix of all sorts of landlords in this work, some that are very obstinate, some that are stubborn, some that are just, very willing to participate and eager for the structure. So each of that is just relationship building, having the patience to come to the conversation with an open mind and open perspective, and recommending mediation at every point is really a key for our programming.
Yeah, I think I try to take it a step back, and in full disclosure, I'm a landlord myself, which I think gives me like a different lens. I see the opportunities and constraints and finances and bottom lines that landlords face at certain scales. And so whenever I think of the uncooperative landlord, I think of that landlord as a potentially cooperative landlord. If only we had better systems in place to help incentivize the behavior that we want and for everybody in our community. So for housing quality, like when I'm talking to someone and they're telling me about what's going on in their unit, I'm like, oh, that's like $6,000. Like, do we have that in the bank? Is there an alternative way that we could encourage a landlord to improve their property and keep rent at a certain amount? Because my biggest fear is that if we polarize the conversation, our landlords are going to opt out. And I can't talk to a phone tree system linked to some sub-LLC out of an LLC, something or other, wired through, I don't know, somewhere else to try to find a solution. But Todd is not the name of a landlord in Hamilton County, but I'll keep just calling him Todd. But I can talk to Todd. And if Todd is providing a unit at the amount that we need for our tenant, and if the fix that he needs is $10,000, then we as a community need to figure out where that $10,000 comes from. And until we have those kind of upstream proactive resolutions, I think that's where my brain space is like, let's have that conversation once we provide a better path for both parties, both tenant and landlord.
I'll kind of add to that. We work with a few courts that do have these kind of funds to help landlords make repairs in their units, or funds to support landlords who are renting to tenants who are kind of higher risk, to make them whole if there is some kind of issue. So I think programs like that can be really helpful in finding ways to link those with the court process, so that landlords who may have some of these concerns, or landlord-tenant pairs that have these issues, can access those resources. But I will also kind of say these are all court-based programs. So at the end of the day, the goal is not to keep every tenant housed in every situation. It's simply to find a better way to resolve this. And it would be a disservice to not mention that in many situations, a tenant will move out. Our goal is that the court can simply find a way to give them a little bit of time and some support to do that in a less damaging and harmful and traumatic way. And that whatever the outcome is, we can make it a little bit easier on the parties, but acknowledging in not every situation will that tenant stay in that same unit.
Hi. So we have a multi-agency center in our community that is aimed at reducing homelessness in our community. We have the Housing Authority, we have Legal Aid, there's Catholic Charities, Family Support Division has an office in there, food stamps, you know, they can get mail there, there's places for showers. So that's something that's been a really nice asset in our community, and we have been able to help people through our legal assistance through the center. But our office is interested in embedding at the court on eviction day to try to catch some more people that way, because so many people come to us too late before, you know, we can't intervene in time. And we've had some informal discussions with our judges, and their concern is that our organization does not represent landlords to help evict people. So the perception is, well, how is that fair if we provide a free lawyer for the tenants, but we're not providing legal assistance for the landlords? And I'm just curious if you encountered that, and if you haven't, if you have any suggestions for us as we continue talks with our local courts about that.
Sure, that's, many courts have expressed versions of that kind of, is this improper or inappropriate in some way to provide space to an entity that's only serving one side of the case. I mean, sure, in an ideal version, there would also be resources for those self-represented landlords as well, because we understand the process can be very challenging for a self-represented landlord in the same way it is for a self-represented tenant, but the volume just simply isn't there. I mean, from the perspective of the court, they're not providing this attorney, they're simply providing information about how a tenant can access this resource, and that's something that's completely appropriate and within the purview of what a court can do, that would really just be considered information sharing, right? Referral facilitation, but is not really kind of overstepping kind of the role of court. And if you have a specific, I'd be happy to follow up with you after that, because these are conversations that we have a lot with a lot of different courts to try to find ways to alleviate that discomfort. And it can be a challenge for courts that just aren't accustomed to kind of sharing space and kind of creating those kinds of partnerships to think about how to do it. But there's nothing that is untoward about it. It's just kind of finding a way to do it in a way that feels comfortable with the court.
I think in that it kind of comes down to like a marketing thing too, a framing or marketing aspect to it in that regard.
Yeah, thank you for the great presentations. I had two questions. One is, do you see the prospect of online dispute resolution, ODR, coming into landlord-tenant matters? I think I've only seen it in Delaware courts, that there's an ODR for housing problems. Do you think that there could be some advantage for kind of digital versions of what you're doing, or some amount of automated versions of the mediation discussions, service provisions, any potential there? And the second one is scale. Is there any way that either in your neighboring counties or neighboring regions that you can promote your magical cocktails of champions to kind of spread to more jurisdictions? And do you have any other plans around scale?
Alexa, do you want to talk a little bit about your ODR platform? I mean, I know it's not eviction, but just kind of how that's worked and uptake.
Yes, I will try my best. I wish Judge McVeigh could just exist everywhere and answer all these questions. But it was a partnership between the General Sessions Court and a pretty large hospital provider in our area, Erlanger. And it is an online dispute resolution program with mediators who are tied to certain cases. My understanding from this first year is that it's showing initial success. And that conversations are taking place around potentially expanding it. I'm not in the room when these things are being discussed, but it does have some pretty key stakeholders and brilliant partners who are thinking through this, that I know for sure. And the conversation hasn't come up around housing. I don't, y'all would know more than me about potential hurdles that would come into effect there, but in terms of replicating and just expanding in general with the beautiful mix and cocktail, like for me, I'm just super passionate about seeing this in an Appalachian context expand, but that's like me. And obviously that would look different between Hamilton County and Polk County and Grundy and all the counties surrounding us with very different ways of doing the legal system and court records and all that.
Yeah, so Michigan does have an online dispute resolution program that's been, I think it was instigated during the pandemic, and from our conversations, it's growing in popularity. We do refer a lot to it. I usually give the option to the client, would they prefer a warm referral for a response or to self-serve during that? And so it's really a mix of whether, personal choice in that regard. As far as cross-county partnerships, our eviction prevention program actually came out of such a partnership with our partners in Kalamazoo County, who had one going a couple years before we started ours. And then from that, we've also expanded that sort of partnership of like having Department of Health and Human Service court presence to at least one other eviction court in our county, in Kent County. So there is a little bit of that conversation happening. I think it's a matter of just, finding the time and energy to exert for those, out of sphere conversations. But I think like the work in this cohort really encourages that kind of collaboration, that cross collaboration. So hopefully we'll have more of those conversations too.
So I don't know if there's anyone in the room from Miami. I know that Miami does have a landlord-tenant online dispute resolution. Anyone? Okay, last time I spoke with someone from Miami, I think they'd had some problems with uptake. It was a pre-filing program, and kind of like everything else, just because you build it doesn't mean people will use it, and I think that's often a challenge. And I do think it matters a little bit whether you're looking at pre-filing or post-filing, and that changes how people will interact with it and kind of what kind of messaging there is. But I see more hands, great.
Hi, thanks. I'm wondering about outcomes and what you're measuring. I'm from Baltimore. We have a pretty notoriously terrible housing stock. Our public housing lists have been closed. You can't even apply for years. So the reality is that, people can't really always budget their way out of poverty into an affordable living situation. So, it's really interesting to hear you talking about not staying in the home and how can we make that landing softer. Like, what do you think the possibilities here are for kind of long-term disruption of kind of cycles of homelessness, poverty? Are you measuring that?
Sure, I'm glad you asked that because I wanted to talk a little bit about data, and so I'm going to tie that into this answer as well. All of our courts here are collecting a lot of data, data that looks much more like a legal aid intake than what a court case management system is typically collecting. We're asking questions around the demographics of people who are engaging with these programs. We're trying to understand the circumstances that brought them into court, what type of legal issues they're experiencing, what kind of referrals and goals and outcomes they're having. And I'm very hopeful that at this conference next year, we'll be able to show fancy pie charts and bar graphs showing that this is all amazing and everyone should sink a lot of money into this. But until then, all we can do is kind of speculate. And kind of our goals are a few. One is we want to simply make the court system work better for everyone. We know there are a lot of structural challenges with how housing courts often work, and we simply want to improve the experience of landlords and tenants and everyone who are going through the system. We also want to kind of stop these repeat situations where people are evicted and then move and then they're evicted again, and wondering if we can invest a little bit more kind of time and resources into this case and resolving it in a less harmful way. Will that stop this cycle that brings people through the court system over and over again? These are some of the things that we are hoping the data will show us, although we're still very early in the data collection, so I can't say that with absolute confidence.
I think one thing that our social workers have brought up a couple times is just the role of the benefits cliff for a lot of our clients. Is they might be able to identify someone through the housing process, work with them over an extended period of time, and then a lot of clients are just facing like a zero-sum opportunity cost decision around mobility. And this is just something in general that we keep running up against is the distinguishing avoiding eviction to how do we define housing stability, and then how do we really encourage mobility over time. And this really came up for us because just anecdotally, I don't have the numbers in front of me. We were trying to see how many of our clients who were coming through legal assistance were coming back into eviction court within a year. And just, having run the numbers like every week, 50 to 60% were coming back within a year and experiencing money judgment evictions. And so trying to find an end to that cycle, I think, is where this program is really going to help us look along that whole continuum, and especially in diversion, be able to reach households and landlords before we're at that point where the debt really is affecting stability and you can't even ask mobility questions.
Do we have any other questions? Or is anyone doing something amazing they would also like to share? These courts are doing great work, but there's more. Oh,
Share.
So I'm just curious about incentives that can be given to landlords. You had discussed earlier the incentive in Hamilton County that, and in other places, in other jurisdictions throughout the country that help pay for repairs and things like that, so landlords can continue to provide housing. Are there any other examples of ways to better engage landlords?
We have some programs that do like high risk remediation. So I think it's like up to $7,000, which can occur. Like there can be extreme damage to a property if in certain circumstances. So we have remediation programs. We do have some programs through the city where there are like benefits packages. But for the higher, larger amounts, there are issues about folks not wanting to turn over the title of their homes as part of that deal. So there are some pretty like strict rules when you start to get into the numbers that are actually needed for structural changes like foundations, electrical, getting things up to code, roofs, HVACs. So we have things. I think they could be better things and probably more networked things. I think even outside of financial, an incentive package could be that the landlord knows where they go. Right now we have a bunch of different programs. We say tenants are confused trying to navigate this system, like landlords are confused too. They don't know who's the case manager with that client and the social worker with that client and what incentive check they got from this. And so they're trying to broker, and if they're confused, they're gonna opt out too. So there's like the incentives of just being a more clear, adequate system for both parties. But yeah, there's resources, but I think we could do better. So if anybody has an answer to that, I'm all ears.
I'll just add to that, if you may have resources you don't even know about in your jurisdiction because they are often not publicized very well, and that's kind of one of the pieces we're trying to solve here is when people come into the court system saying, hey, did you know about X, Y, and Z, and trying to make it easier to access those. So it's possible you may have programs, they're probably underfunded, but you may have programs that you should already be trying to tap into and advocate for those to be expanded if you're allowed to advocate for things.
That's a really great question to bring to your landlords groups and property management meetings, to kind of just ask specifically, what are incentives that would work for you? What would you like to see and work? It's a good way to bridge a conversation, get creative as well. But those are the conversations that we're having right now with our own RPOA to kind of find the solutions, because our county doesn't have any sort of incentive programs for landlords. So it does, a lot of the time right now, I find myself trying to sell the program, sell the idea to landlords, and we are really grasping at, well, it benefits you if it benefits your tenant. All you want is a tenant that pays your rent and keeps your house okay. So yeah, it's a good conversation starter to have with your landlords too.
Let's add into that. This is a little bit related to your question. It's not financial incentives, but one other question we often get asked is, how do you get landlords to engage with the pre-filing program? What's in it for them? Isn't that just going to slow down the process and so forth? And one creative thing that our court in Alaska is in the process of working on is a series of rule changes where if a landlord and tenant kind of negotiate an outcome pre-filing and then the tenant defaults on it, that settlement agreement will be entered with the court kind of under a different case type, and not as a public record, but the landlord can go in and then kind of enforce that judgment. They're not gonna have to start a new case from the beginning and kind of be penalized in that way for, in good faith, trying to negotiate a pre-filing outcome. So there are kind of ways to incentivize participation and diversion by just thinking about, from the landlord perspective, what security do they have that this isn't going to ultimately disadvantage them if they try to do something right and it doesn't work out. And there are other kind of ways too to think about waiving filing fees and kind of, other ways to help them move a case forward if it ultimately does have to go to litigation. Okay, I think we have time for maybe 2 more questions.
I didn't really have a question, just wanted to provide another example of a diversion. My name is Mike Commons. I work for the Indiana Bar Foundation, and Samira knows, well, she, in her slides, Lawrence Township was one of those, and so Judge Bacon is somebody that we work with. And one of the new innovations that we've got going on is we have used federal ERA dollars that have come into the state agency, Housing and Community Development Authority, to build self-service legal kiosks that we're placing in every county in Indiana, 120 kiosks, and there's one in Lawrence Township, and it's a freestanding, looks like an ATM touchscreen where, and for now, all of those kiosks are focused on housing and eviction issues, and so self-represented litigants can access information and resources, links to housing counseling information, links to the landlord-tenant settlement conference program so that they can fill out a request to participate in that process, as well as court forms for eviction records sealing filings, in circumstances where their case records can be sealed. And so this is just another example of one of the other diversion options.
Absolutely, the kiosks are fantastic and just a really great additional tool to have kind of in making all of this work better. All right, I think we can maybe do one more question if there's any other hands.
I don't want to end on a depressing note, but do you think the policy window is closed now? If ERA money, if there's all these other problems in society, is the eviction question, even if we in this room know that it's still a huge problem, from city government and other non-court, non-legal aid, do you feel that the policy window is closing?
I mean, I don't think so. I think there is no secret that eviction filings are up, homelessness is on the rise, affordable housing is scarcer than ever before, and I think that local leaders and court leaders are aware of that. So I think the policy window is never closed. It's just finding a way to use it. I don't know, either of you want to weigh in?
Yeah, we're kind of changing the conversation to be more the community response and less state and municipally funded ERA resources. So we're very poised to use the, we are in the midst of the eviction tidal wave that we were expecting post-COVID, that the ERA came in to try to stop and stymie. But so we're using that to look to community and private funding sources for these problems as well. So I think it's actually kind of expanding.
Yeah, this is a very Southern framing, but at the end of the day, the drum that I always beat is ineffective systems, unfair systems, unjust systems. They're just expensive. Like, they just cost a lot of money to constantly be trying to solve problems as communities, cities, counties, states, like real far down the pipeline. And that for me is always like, yes, there's a magnifying glass and there's a lot of attention paid, but it feels like the window's getting more open because the conversation feels very real right now, at least in our context around like, this isn't just a pie in the sky, this is what I hope the world will be conversation. It's a like, at some point we need to think about how much inefficiency and unfairness cost us. Cost our hospitals, cost our businesses, cost our neighborhoods, cost our schools. And if we can start to move into that territory, and that's a across the aisle, everyone cares window of opportunity, because it's just smarter to do things better for our citizens and our residents.
I'm going to end us on a happier note, and a shameless plug, a twofer. So here is our website. Next week, we will be releasing a request for applications. We are looking for more funds, or more courts to fund to do this work. And the window of opportunity is absolutely open. And we really encourage you all to encourage your courts to apply. So please check our website or email me if you are interested in getting that request for applications. And we really are happy to talk more about what this program is and the kind of work that can happen. And I'm going to ask Kathy and Alexa to each say one great thing about being a part of the EDI cohort. Go.
What, me first?
Now they have no answers.
Honestly, I want to thank y'all for the learning community. I know Yoshiko, who's our housing stability facilitator, the moment we started to get movement and excitement on the ground in Hamilton County about a mediation model, cohorts, resources, access to you, access to the evaluator, meetings were lined up, information was flowing in. It's been a very solid community of learning to where we don't feel like we're out there floating around on Google and hoping for the best.
Yeah, I'll have to speak to the passion. Working on any project with partners that are as passionate as you or driven, again, mission and purpose-driven work, especially like this, is extremely beneficial because you're working with clients that have very bleak situations. We all get that burnout, but it's really great to come back and have this cohort of passionate individuals that are really driven in the work and the resources. Can't beat the resources. Trench work support. Yeah.
So there you go. Our contact information is up here. Please feel free to reach out with us. We can also hang out for a few minutes, but I think we're at 5. So thank you so much for joining us today.